It is time to check in with Chris Dimakos, our CJAD 800 legal contributor. And Chris, interesting query today. EI benefits, right, in Canada are supposed to help employees who are out of work. Nothing new there. Problem, however, that you raise, are you eligible for EI benefits if you quit? What's the deal on this?
Right. So there's a general principle for EI benefits that if you lose your employment through no fault of your own, well, then you more than often are entitled to EI benefits. The problem happens when you quit or you resign. When you fill out your paperwork and you say, "Well, I'm the one that ended my employment," usually you get a big no. No, you're not entitled to it because you made a decision, the conscious decision to end your employment. What many people don't know is that there are provisions within the law that state that if you had to leave your job because of the circumstances from what you're working at, could be the poor conditions, it could be personality conflicts, it could have made work very difficult for you to keep attending. In those cases, much like a constructive dismissal, right? When you're forced to quit because the employer is pushing you out the door, in those cases, you are eligible to qualify for EI benefits. So what's important for everyone to know is if you're at a job right now, you haven't been fired, you just cannot continue going to work. It could be because of the way you're being treated. It could be because you're not getting paid. There could be a number of reasons that would justify you leaving that job. Well, in those cases, you would be eligible to qualify. When you fill out your paperwork for EI, there are spaces and there are paragraphs where you can explain why you left. And there's even reviews and appeals and a whole bunch of stuff that's there to make sure that you get what you're owed. But the main point I'm trying to make is just because you quit, because I've often heard that, well, if you quit, you lose all your benefits. The general rule is if you quit because you don't like your job or you just want to change, that's one thing. But not if you were forced out, not if you were forced to resign, much like a constructive dismissal. So it's important to make that distinction.
Okay, so I'm sensing as you say this, someone reacting by saying, well, I'll have to prove if it comes to this and I want to collect benefits that in fact I was forced out, when the employer is simply going to say, oh, no, we didn't force anybody out. He decided to leave on his own. Sounds to me like you're in for a bit of a legal hassle here.
So again, your instincts are bang on. Yes, you're the one that's going to have the burden of proof if you resign. And that's why I always say before you do something, make sure, A, that you get the information you need, that you document it. It could be, for example, a conflict with your manager. It could be an uncomfortable conversation. There could be language used that caused you to want to leave there, that you were major name calling, or whatever it is. You have to document as much as possible what's going on. You have to communicate, whether it's with HR at your company, whether it's with your direct superior, whoever it is, any type of paper trail, any type of evidence you have that suggests what you're saying is true and actually happened, that goes a long way when you're trying to prove your case. And you're absolutely right about that. It's your burden of proof. So you have to be smart about this. Don't just decide on a whim, I'm going to resign here without taking the necessary precautions to make sure that if you do so, and your intent is to collect EI benefits, that you take the necessary steps before you leave, and you document why you're leaving, and you download or you copy or you forward any emails that would support your case in that context.
So, I mean, I'm sure you've had situations like this, right, where exactly what you're outlining now has come to fruition. What typically happens to employers, at some point? Let's say you followed what you suggested, right? You've documented all these situations that have happened between the time you were told you have to leave or you decided to leave. Is it still a matter of he said, she said when you end up in court if your employer decides to go after you? Or for the most part, do they simply say, you know what? Okay, we realize we're not going to win. He or she has documented all these things. Let's let it go.
Right. So there's two things here. The one is the he said, she said. You're absolutely right about that. And the best evidence that I look for when someone comes to see me about planning their case, I want to see evidence that's not subjective, that's not opinion, that's not someone's version of facts. I love an email that's written down that someone can read it and say, that email was sent. The words are those words that were used, and anyone can interpret them the way they want to interpret them. Or if you got a performance review, or if you have any type of documents that you can read and know that this is exactly what was done. This is what was said in those documents. There's very little, like you said, he said, she said, no, that's not what I said. I said this, and no, nobody recorded the conversation. It was just us two. So anytime you have this evidence that cannot be contradicted, those are the ones that carry the most weight. But again, I always tell this, the best cases, the ones where you get the strongest settlements, the ones where you have the least resistance, are the ones that are the best prepared. You know, they say, like in hockey, the best saves are the ones that are made before the shooter even shoots the puck. It's the preparation that the goalie took to prepare himself for the shot. Well, the same thing in legal cases. The strongest cases are the ones that don't ever get to trial. They've been prepared properly, strategized properly, and when you show up and there's a meeting between both parties, one party says, you know what, there's very little to do here. Let's just try to mitigate how much exposure we have, and not whether or not we should try this case. Let's just try to limit the damage.
All right, I want to move on from that while we still have a minute to get into this case that you brought up. So a father hands over his multi-million-dollar business to his son for his son to run, and then the son makes a mistake. He fires an older employer who's been with the business for more than 35 years by referring to him as, I'm quoting, old school mentality, and that's the reason he was let go. Employee files an unjust dismissal claim. What happens?
Well, he obviously wins. Not only does he wins and gets awarded above and beyond that 24-month max soft ceiling that we have in employment law. Well, the court went above and beyond that, and again, this goes back to preparation. What people should understand here is this new owner of the company, the son that was handed the company, decided to let the employee know and testify in court. Yes, we let them go because they were old school. They like to do things the old way, and I want to do things a new way, and that's why we let them go. Well, that doesn't bode well when you're trying to prove to the court that they can find other similar employment under the same conditions. If you're telling the court that this person is not employable anymore because they're old school mentality, that's not going to help you prove that they can get a job nice and quick and don't need much severance. You're shooting yourself in the foot, which goes back to preparation. Sometimes I see some of these cases and I'm like, how did this individual not know that testifying in this way is going to hurt his case? I'm not sure. They probably took it for granted. But again, the purpose of severance is to get you from your current job to your next employment. And sometimes that just is very, very difficult to foresee how much time it is. And in exceptional circumstances, the courts are going to say, you deserve the max and then some, because even your own employer said they have an old school mentality. It's going to be very hard for them to be employed by anybody because of that. So what people should take from this is understand exactly what the law says when you file a claim. Understand what you're trying to prove, and if when you prepare your case, make sure you're not testifying in a way that actually shoots yourself in the foot. Because I've seen it many times. Make sure understand what the objective is, and make sure that your evidence is in line with what your objective is.
Chris Dimakos, more helpful advice. Thank you, Chris. Appreciate it.
Thanks, Aaron.
Seasoned gamer or just video game curious? This Week in Gaming is the podcast for you. We break down the latest in the world of video games, from basics to beyond. The hottest gaming news, insight, and industry leaders and more weekly. Join me, Naomi Kyle, and stay ahead of the game with all the latest updates, even if you're a total newbie. Stream This Week in Gaming on the free iHeartRadio app or wherever you get your podcasts.